Good morning, everyone. We're going to start. My name is Rodrigo Montes de Oca. I'm a research scholar at the Baker Institute Center for the United States and Mexico. I want to welcome you to the sixth event of the Mexico 2025 and Beyond initiative. Launched in March 2022, this initiative seeks to visualize and forecast the probable scenarios in the post-Lopez Obrador era and the binational relationship. Today's event is in fact very timely for this initiative. Many countries in the world are facing serious threats against the independence of their judicial branches. In some countries, the danger comes from organized crime. In others, elites who want to undermine institutions. In others, they come from politicians who want to turn impartial judges into political actors. What these all have in common is their undemocratic approach to justice and the arbitrary use of the law to perpetuate themselves in power and to persecute their rivals. But no matter what the source of attack of judicial branches here and there, the outcome is always the same: to undermine the checks and balances system that provide each branch of government specific powers to check the other branches and prevent any branch from becoming too powerful. Unsurprisingly, and sadly, Mexico is not the exception. Since President Lopez Obrador took office in 2018, he has been trying to capture the judicial branch. His efforts have been partially successful. In 5 years of his administration, Lopez Obrador has accepted the resignation of 2 Supreme Court justices. One justice resigned for an alleged corruption scandal that was never proven. The other justice decided to join the presidential campaign of Lopez Obrador handpicked candidate, Claudia Sheinbaum. The latter will permit President Lopez Obrador to appoint yet another Supreme Court justice during his term. Thus, during the 6 years of his administration, the president will have appointed 5 out of 11 Supreme Court justices, and his successor will nominate 4 more. This means that by 2030, Mexico will have an almost renewed Supreme Court of Justice. Under current trends in appointments, the executive may end up with a completely co-opted Supreme Court in just a few years. That is very likely today, as we have witnessed in the last months. The President Lopez Obrador and his party Morena have ramped up attacks against the judicial branch and individual justices and judges. Moreover, to disable the judicial power, the Mexican Congress passed legislation eliminating 13 endowment funds that provides benefits to the federal judiciary workers. In response, constitutional challenge had been brought against the bill. The outcome of this is, of course, still pending, but the court will be in a difficult situation where it must rule in a case where it has an interest. This will raise questions about the impartiality and authority of the Supreme Court. Unfortunately, any questions about the impartiality and authority of the Supreme Court is bad for the rule of law of the country. And Lopez Obrador will strengthen the public perception that the courts are meddling in politics and are not impartial. This all a harbinger of things yet to come. And we suspect that he will continue attacking the judicial branch and its member in what is effectively an electoral year, 2024. In this complicated context, we have the honor to host Justice Alfredo Ortiz Mena here at the Baker Institute. Justice Gutiérrez Ortiz Mena was appointed by President Enrique Peña in 2012 and will serve for a 15-year term. While on the bench, he has championed women and children's rights, gender equality, and diversity. He has written landmark opinions regarding abortion rights, discrimination based on sexual orientation, arbitrary detentions, torture, and abuse of force by police. Something that is not well known and that must be recognized about Justice Gutiérrez Ortiz Mena is that he has been and continues to be a promoter of a new and diverse generation of members of the judiciary. Most of his former law clerks are part of a new generation of highly competent judges and magistrates that are changing the face of the Mexico judicial power. Before sitting in the highest court of the country, he was the director of the Tax Administration Services, an agency that is the equivalent of the IRS, and worked for different Mexican and international law firms. Justice Gutiérrez Ortiz Mena holds an LLM from Harvard University. Prior to that, he received a law degree from the Universidad Nacional Autónoma de México. As a graduate student, he was awarded a scholarship from the Fulbright Garcia Robles Foundation. After his LLM, he took and passed the New York bar. He is licensed to practice law in Mexico and in the US. Justice Gutiérrez Ortiz Mena will deliver his remarks. Then he will engage in a conversation with Tony Payan, director of the center. And finally, there will be a Q&A session with the audience. So now, please join me welcoming Justice Alfredo Gutiérrez Ortiz Mena.
Good morning, everyone. I hope it's not too early to bore you with constitutional issues. First of all, I want to thank Rice University, the Baker Institute for Public Policy, Rodrigo, Tony, thank you very much for inviting me and having an opportunity to get my thoughts together on what has really been a very tumultuous couple of years at the Supreme Court. We're judges. We're not used to this much attention. Today, my remarks, I'll keep them relatively brief and hopefully not too boring. But what I wanted to reflect on today is how the court got to where it is. Why is the court important today? 30 years ago, it was a very insignificant power in Mexico. We really didn't have a constitutional court. We had a court of mere legality, and constitutional issues were not taken seriously. It really, there was a strong belief that the Constitution was not justiciable in court. This to Americans may seem a little strange, but there's a reason for it. 70 years of one-party rule, and the president concentrates an enormous amount of power, and that makes the other branches of government less important. So if you'll bear with me for a couple of minutes, I just want to take you through a historical analysis of how the court got to where it is today, why the court today is such an important institution in Mexico, and hopefully that'll allow you to understand what the dynamics are in Mexican democracy once you understand where the Mexican Supreme Court is situated. So if you'll bear with me, I'll divide today's presentation in two parts. First, a brief overview of how the Mexican Supreme Court evolved into a constitutional tribunal. And second, how the text of the Constitution has been interpreted by the Supreme Court in its role as a constitutional court. And as we'll see later on, the current Supreme Court has issued very important rulings with respect to civil liberties, especially where minorities are concerned. And at the same time, the court has demonstrated self-restraint on issues of public policy better left to the democratically elected branches of government. Now, in the U.S., you can point to Marbury versus Madison in 1803, and this case is cited to establish that the U.S. Constitution is law and that federal courts have the power to refuse to give any effect to legislation that is inconsistent with the Constitution. Judicial. In Mexico, it is not possible to point to any specific case or fixed period of time. In a nutshell, it is not possible to point to any specific decision that would be equivalent to Marbury versus Madison. The evolution of the Supreme Court into a constitutional court was a much slower process. It began in 1917 with the enactment of the Mexican Constitution. This written constitution was seen during much of the 20th century as more of a political text than a legal document, and to a large degree was not justiciable in courts of law. Towards the end of the last century, and coinciding with Mexicans' evolution as a democracy, two fundamental amendments to the Constitution provided the framework needed to transform the Mexican court into a constitutional court. After a century of evolution, the Supreme Court today has become an arbiter between the elected branches of government, between the federal government and the local states, and assumes a counter-majoritarian perspective to protect civil liberties, human rights against majority. So let me begin today with a very brief outline of the Mexican Constitution, which was modeled at its core from the U.S. Constitution, but has some very important differences. For example, it was the first constitution in the world to recognize a series of social rights, such as labor, agrarian, education rights. It also expressly emphasized the state's role in achieving social welfare. Now, this state's role has meant different things at different times. In the last century, it has meant state ownership, strict regulations, and autarky. But more recently, it has meant government regulation within the context of competitive markets and free trade. In addition, our democratic model and our system of constitutional justice also differ greatly from the U.S. model. Our democratic model is heavily regulated in the Constitution and has been the subject of many constitutional reforms. These reforms have led to changes how the Supreme Court interprets our democratic model. In its origins, our democratic model was like the U.S. model. It was based on the principle of majority rule. One person, one vote. This model was abandoned in the last quarter of the 20th century. Mexico adopted a democratic model of proportional representation. Congress was to be comprised by representatives who had won an election and by representatives of political minorities who were not elected by majority. Today, Mexican Congress is bicameral, House and the Senate, with members who are elected by majority rule and by proportional representation. The House of Representatives has 500 members. 300 are elected by majority rule and 200 by proportional representation. The Senate has 128 members. Each Senate elects 3 senators. Each state elects 3 senators who are elected by majority rule. 2 are elected by majority rule, and the 3rd senator comes from the political party that obtained the second most votes. The 32 remaining seats are assigned by proportional representation from a list of which the parties negotiate. Another difference worth noting is the funding and carrying out of elections. Again, the Mexican electoral system differs from the American model. For starters, we have a national agency entrusted with the task of counting every vote in the federal elections, distributing public funding among political parties. Private funding is very, very limited. Inspecting their expenses, issuing a national voter ID card, keeping electoral districts up to date. It is not done by Congress. So the issues you have in the U.S. of gerrymandering are settled in the Electoral Institute, and punishing political parties for electoral law violations. Also, we have a specialized jurisdiction entrusted to the Federal Electoral Court so that the voters and parties can challenge in federal court any decision issued by the electoral agency. It is important to note that even though we have an electoral court, only the Supreme Court can review the constitutionality of electoral laws. Finally, our system of constitutional justice differs from the U.S. model. The American model of judicial review grants the U.S. Supreme Court and federal courts the authority to review the constitutionality of laws and other government actions. This authority is exercised when necessary to adjudicate a specific case or controversy that comes before the court. This power is not explicitly mentioned in the Constitution, but has been inferred from the court's interpretation of the Constitution. In Mexico, the power of judicial review is explicitly and very detailed in the Constitution. Originally, the Constitution of 1970 adopted the writ of amparo, which was the only constitutional remedy at the time. In its beginning, this writ could only be used to review violations of civil liberties, and all rulings that were only applicable between the parties directly involved. Structural parts of the Constitution, say, for example, division of powers or states' rights issues, were non-justiciable. Electoral issues were also non-justiciable. Implicitly, they were within the purview of the President of Mexico. Under this model, the Supreme Court had a very limited power of judicial. In 1994, a constitutional amendment created two new types of constitutional remedies: the writ of constitutional controversies, controversias constitucionales, and the writ of unconstitutionality, acciones de inconstitucionalidad. This amendment cannot be understood without some historical context. Mexico was finally taking democracy seriously. Opposition parties were in a real position to contest the 70-year rule of the governing party. In fact, 3 years later, the opposition was able to control the lower house of Congress for the first time in the 20th century. The new constitutional remedies enabled institutional differences between elected branches of government to be settled in courts of law and not in political vacuums. From this point on, and for the first time in modern history, the Supreme Court became a very visible and very important branch of government. The writ of constitutional controversy was designed as a way for the Supreme Court to resolve conflicts pertaining to the division of powers and federalism. It's brought directly before the Supreme Court. Standing is limited to any one of the federal branches, some government autonomous agencies, local states, and municipalities. It allowed the Supreme Court to assume stewardship of our model of federalism and division of powers, a role historically and implicitly reserved to the President of Mexico. Unlike other constitutional remedies, the writ of unconstitutionality allows the Supreme Court to rule on the constitutionality of laws in abstract, without case or controversy. Standing is granted to legislative minorities, 30%, political parties, and human rights commissions. This writ is the only constitutional remedy available for challenging electoral laws. Stewardship of our democratic model is the responsibility of the Supreme Court. The second constitutional amendment, which strengthened the role of the Supreme Court, is more recent, 2011. This amendment modified Article 1 of the Mexican Constitution and expressly mandated an affirmative duty of the entire Mexican state to protect, guarantee, respect, and promote all civil liberties recognized in the federal Constitution and all human rights recognized in international treaties to which Mexico is a member. It also constitutionalized the pro persona principle for interpreting civil liberties and human rights. Judges must interpret a civil liberty or human right in a way that ensures maximum protection. It reflects a commitment to interpreting civil liberties and human rights in a manner that fosters the realization of rights and freedoms rather than unduly restricting them. To summarize, the 1994 constitutional amendment granted the Supreme Court stewardship over the democratic, federal, and division of power models. The 2011 constitutional amendment assigned the court a counter-majoritarian role in Mexican society. Two recent court decisions have allowed the Supreme Court to consolidate the justiciability of the Mexican Constitution. The first doctrine is an expansion of judicial review to all judges at the federal and state level. The second court doctrine implies the expansion of substantive rights. This second doctrine is the functional equivalent to the U.S. incorporation and substantive due process doctrines. The first case stems from the Supreme Court's duty to comply with a ruling by the Inter-American Court of Human Rights. That case is Rosendo Radilla Pacheco versus Mexico, also known as Radilla. In Radilla, the Inter-American Court of Human Rights ordered several steps to be taken by Mexican authorities, which led to structural changes in how judicial review is understood by Mexican courts. Under our traditional doctrine, judicial review was limited to federal courts in a specific type of constitutional remedy, the writ of amparo. Imagine, for example, that in a civil case in a local court, the judge comes upon a law that was clearly unconstitutional. Under our traditional doctrine of judicial review, he would have a duty to apply the unconstitutional law to the case at hand. Only once the petitioner had exhausted all local appeals could he petition via writ of amparo to a federal judge and challenge the constitutionality of the local law. If he was successful, his case would be retried, this time setting aside the unconstitutional law. You can forget about any notion of a speedy trial. In compliance with Radilla, the Mexican court in 2011 issued a rule that modified our traditional and very limited doctrine of judicial review. In essence, the new doctrine was very similar to the U.S. doctrine of judicial review laid down in Marbury versus Madison. Under this new doctrine, local and federal courts have the power to refuse to give any effect to legislation that is inconsistent with the Constitution when it is necessary to adjudicate a specific case or controversy that comes before the court. The second doctrine was established in two cases in 2000. The issue was whether human rights treaties were justiciable in Mexican courts and if they were below or above the Mexican Constitution. The Supreme Court ruled that human rights found in treaties where Mexico is a party are incorporated into the Mexican Constitution by virtue of the constitutional amendment to Article 1 mentioned above. This doctrine greatly expanded the scope of rights guaranteed by the Mexican Constitution through the incorporation of international human rights. In much the same way, local states have incorporated federal constitutional civil liberties in the U.S. through the Due Process Clause of the 14th Amendment. This new framework opened the floodgates, and the court entered an era similar to the Warren Court of the 1960s. And let me briefly touch upon a couple of seminal cases to illustrate. Acteal and the constitutionalization of criminal procedure. On December 22nd, 1997, in the southern state of Chiapas, in the small town of Acteal, 45 indigenous Tzotziles were massacred. Two theories about what happened that day began to emerge. One theory was that the massacre was a result of infighting within the community due to religious differences. The other theory was that the massacre had been committed by paramilitary groups linked to the official governing party to repress indigenous communities sympathetic to the revolutionary Zapatista army. As could be expected, the government adopted the first narrative, religious infighting, and several indigenous Tzotziles were charged, tried, and convicted of murder and related crimes. 10 years after the massacre, a university legal clinic filed a writ of amparo, habeas corpus, on their behalf. The Mexican Supreme Court granted certiorari. The plaintiffs argued due process violations during the trial. The court found grave and systematic due process violations during the original trial and adopted for the first time, as a remedy, the exclusionary rule to set aside almost all the evidence. In a manner very similar to the revolution from above of the Warren Court in the 1960s. In Mexico, after Acteal, the matter of legality of police conduct is as important as the accused's guilt or innocence. Criminal procedure had finally been constitutionalized. Civil liberties and same-sex marriage. In 2014, a year before Oberfeld versus Hodges, a group of residents from the southern state of Oaxaca filed a writ of amparo in federal court. The plaintiffs affirmed to be homosexuals with no intention of getting married. Nevertheless, they petitioned the court to declare Article 149 of the Civil Code of Oaxaca unconstitutional. This article defines marriage as a contract between one man and one woman. The federal judge dismissed the case without prejudice. His reasoning was that since the plaintiffs expressly stated that they had no intention of getting married, the plaintiffs lacked standing and their case lacked the sufficient ripeness to be adjudicated at the present time. Plaintiffs appealed the decision, and the Supreme Court granted certiorari. Logically, the first issue the court had to face was standing. Did standing require state action? Were the plaintiffs required to attempt to get married before the minimum standard of standing and rightness could be achieved? The court said no, they did not. Article 149 of the Civil Code of Oaxaca, by defining marriage as a contract between a man and a woman, implicitly excludes other types of marital arrangements, and therefore sends a stigmatizing message to society, reinforces negative stereotypes, and causes structural discrimination. Sufficient reasons to grant standing and to rule in favor of the plaintiffs. The Supreme Court clarified that a stigmatizing message is different from an ideological opposition to the contents of it. The injury necessary for standing must be objective and unequivocal and caused by an indignant categorization of a suspect class of persons, race, sexual orientation, gender, etc. In this manner, the court expanded the doctrine of standing to protect minorities from negative stereotypes and structural discrimination. Civil liberties and abortion. In 2007, Mexico City decriminalized abortion. The Attorney General, the federal Attorney General at the time, challenged the constitutionality of this new legislation, decriminalizing abortion. The Supreme Court upheld the constitutionality of the new legislation to decriminalizing abortion in Mexico City. The reasoning at the time by the Supreme Court was that criminalizing or decriminalizing abortion was a state issue. States could freely legislate on matters of criminal law and abortion. After the ruling, 20 of the 32 states passed amendments to their state constitutions to protect life from the moment of conception. During the following years, plaintiffs in abortion cases began arguing justifiable defenses where the accused would argue that their actions, which would normally be considered criminal, were justified under the circumstances. The court granted certiorari in several cases and began expanding the type of cases where justifiable defenses would succeed: rape, health risks, pregnancies of minors, etc. Finally, in 2021, and in a reversal from 2007, the Supreme Court unanimously held that the federal Constitution recognized a woman's right to her personal reproductive autonomy. Legislatures were no longer free to decide when life begins or to interfere with the rights of women and pregnant persons in the decisions they take with respect to their reproductive autonomy. Central to this reversal was a 2011 constitutional amendment that modified Article 1 of the Mexican Constitution that expressly mandated an affirmative duty to maximize the protection of civil liberties and rights. The same-sex marriage and the abortion rulings were very unpopular in a conservative society like Mexico. The same-sex marriage ruling is the only time in my 10 years on the bench that I can remember protests in the streets against a Supreme Court ruling. Both cases show a commitment by the Supreme Court to assume a counter-majoritarian role when adjudicating issues involving civil liberties and rights. Public policy and judicial restraint. 20 years ago, the Supreme Court established a doctrine on the constitutional justiciability of tax legislation. Horizontal and vertical rigorously applied when analyzing tax legislation. Tax legislation became a form of constitutional legislation. A large amount of tax legislation was struck down as unconstitutional. The court back then was jokingly referred to as the tax court. An excellent parallelism to illustrate this phase is the criticism gained in the U.S. Supreme Court during the Lochner era and the New Deal provisions enacted by President Roosevelt. The solution to the crisis then as now is the same: deference to the elected branches of government must exist when reviewing economic public policies. Insisting on using personal preferences to review markets or economic regulations calls into question the legitimacy and partiality of constitutional judges. Constitutional courts should never use their personal preferences as the standard to judge public policy enacted by elected officials. Objective standards must be applied. In the U.S., deference to the other branches of government in areas of economic public policy began in 1937 in West Coast Hotel versus Parrish, where the U.S. Supreme Court upheld that economic laws ought to be reviewed on a rational basis test. The exception to the rule came with footnote 4 in the United States versus Caroline Products, which established that the standard changes from a rational basis test to strict scrutiny only when economic regulations interfere with civil liberties or discriminates against discrete and insular minorities. Today, the Mexican court will apply a rational basis test, deference to the elected branches of government, when deciding cases that involve economic regulations. The court will look to see if the government action has a rational basis for achieving a legitimate government interest. Strict scrutiny, on the other hand, is a much more rigorous standard. Here, the court will look to see if the government action is narrowly tailored to achieve a compelling government interest. In Mexico, strict scrutiny is applied as the standard of review when a law or government action involves a suspect classification, gender, race, or significantly infringes on a civil liberty. In recent cases, this has bared out to be true. One case was some potato producers questioned the constitutionality of provisions in the Federal Vegetable Sanitary Act, which regulates the conditions for importing potatoes. In choosing the level of scrutiny, the court considered the technical and scientific nature of the regulations and concluded that a mere rational basis test should be applied to determine whether the regulations are in accordance with the Constitution. However, if the regulation would have interfered with civil liberties, human rights, or discriminate against suspect classifications, they would have been analyzed under a strict scrutiny test. For example, in 2015, the Supreme Court ruled that an absolute prohibition on the recreational use of marijuana was unconstitutional. Public health concerns may regulate private conduct, but not to a degree where privacy and personal autonomy are rendered non-existent. Clearly, the court applied a strict scrutiny test and found the absolute prohibition wanting. Final thoughts. As we can observe from today's very brief description, the Supreme Court has evolved from an insignificant branch of government to an authentic constitutional court. Many factors have played into this evolution: constitutional amendments, court doctrine, and most of all, a flourishing democracy. The court's role as a constitutional court is not the same in every issue it faces. If the task involves protecting civil liberties, human rights, or minorities, its role becomes counter-majoritarian by imposing limits on the majority's preferences. But if the task consists of controlling the direction of state powers and public policy, its role becomes the guardian of majority. The court has also substituted implicit powers of the president by becoming an arbiter between elected branches of government and between the federal government and local states. Will this last? I think that is a question better put to the Mexican elect. Thank you very much.
All right, I'm going to use this to moderate the question, Q&A. I have a few questions of my own, if I may, to begin with. Your last question is the most provocative. Will this last? Right, and I think it's probably a good opportunity for us to begin to sort of think about the future of the court in Mexico. The president, however, President Lopez Obrador, is a smart politician. He's very able. He really understands where to go to put pressure on the various institutions in Mexico and find ways to try to weaken them. And one of them is to seek the election of judges, including Supreme Court justices. What is your initial assessment? Will that happen? What are the potential consequences? What will it do to this 30-year effort to build an effective judiciary in Mexico that constitutes a really important check on the power of the other branches? What would the requirements be? Will the Mexican electorate buy this way of organizing the judiciary? What would that do to the court and the judicial system, the branch in Mexico?
Well, let me start by saying that constitutional courts, like the Mexican court or the U.S. court, are not necessary to have a democracy. The UK didn't have a constitutional court until it entered the European Union. The Netherlands doesn't have a constitutional court. New Zealand doesn't have a constitutional court. So the electorate has to be convinced that there's a positive side to having a constitutional court, because you can have a democracy and not have a constitutional court. That said, I find it difficult to think that we are going to enter a period where there is going to be enough political interest in disbanding the court or changing the court to a place where it would not be recognizable. That would be difficult. Understanding that you don't need a constitutional court to have a democracy, so maybe the electorate will decide to change the situation. We'll have to wait and see how that evolves.
More recently, in what Rodrigo called an effort of the executive power in Mexico, at this minute represented by the President Lopez Obrador, has sought to weaken the court. And one of those ways is to essentially nationalize or take the endowment funds, the trust funds that fund not the justices, but the branch, the employees of the branch itself. Now, this has obviously been appealed. It will likely end up in y'all's hands, so to speak. How do you see the court? In what position do you see the court having to decide on a matter that is directly related to its employees? That's a tough spot to be, potential. What do you think?
Well, I can't get into the specifics of the issue because the issue is before court, and I can't give an opinion about issues that will quite likely reach the court. The issue of conflict of interest, there are a lot of precedents. It's the doctrine of necessity. The U.S. faced this issue when there was inflation in the United States. I believe it was in the 70s. There was a case about what raising the pay of federal judges and Supreme Court justices and the like, and the Supreme Court ruled. And the doctrine is a doctrine of necessity. We have applied that doctrine. Nobody else can rule on it, so by necessity, the court has to rule on it, regardless of conflict of interest. That's basically, in a nutshell, what the doctrine of necessity says. We use it in acciones de inconstitucionalidad and controversias constitucional because we're 11 members of the Supreme Court and we need 8 votes to invalidate a law. So in those types of constitutional remedies, justices cannot excuse themselves. And they cannot excuse themselves because there is a necessity to reach 8 votes. So that doctrine already exists. It's been applied. It's been applied in other issues. I don't think that will be the issue, but I can't get into the specifics of the case itself because it's pending before the court.
Thank you. Another issue, obviously the court requires protection and the judicial branch requires a certain degree of protection, certain mechanisms that isolate it from the power of the executive. But I think the executive in Mexico seems to have found a formula to employ Trojan horses by designating a number of individuals to the court that might be interpreted as doing the bidding of the executive rather than strictly adhere to the role as representatives of the court. The president himself has said that he designated a couple of people that he didn't, he considers, I think, disloyal to him because he put them in there, almost explicitly acknowledging that to do his bidding. And now there seems to be another opening on that. So are we looking at a political Trojan horse that the president is using to continuously penetrate, so to speak, infiltrate the court and weaken it? What is that? How am I viewing what is going on correctly?
I have a different view. I think what happens in the ballot box has real consequences in society, and I think what we're seeing is the result of what happened in the ballot box in 2018. The constitutional arrangement provides for the president to send 3 names to the Senate, and the Senate must choose from those 3 names a justice. That said, I find it very hard to believe that we are going to have justices who are going to put their personal preferences over how they interpret the Constitution. Once you become a justice, your loyalty is to the Constitution, not to any individual. And I think that has borne out today. The president has sent already 4 persons to the court, and I think they've done a very, very adequate job. The fact that the president can send names to the Senate and the Senate has to decide between those 3 names, that's democracy. If the president convinces and the ballot box goes in his favor, well, then he will have a Senate that will allow him to send the names that he considers the best candidates for the job. But thinking anything else is saying, well, I don't like democracy. And the bottom line is, I don't like who got to the presidency, and I don't like who's in the Senate. And I think that's not the way we should see it. I think this is democracy working, and these are the results, these are the consequences of what takes place in the ballot box.
Yeah, and this is obviously something we're faced in the United States as well, because the court has become more ideological as a consequence of the opportunity of various more conservative presidents to appoint the people that agree with them. So clearly we also have a Supreme Court that's largely co-opted to the right today in the United States. And so I understand your answer. The other question that I have before we open it to the audience for discussion is the question of the isolation of the court from the people. The cases that you named, many of us are familiar with them. They're important cases that have broken ground and expand the horizon of civil rights and liberties in Mexico, and place the court squarely as a defender of these rights. But what would the relevance of the court be to somebody living in the mountains of Chihuahua, in the jungles of Chiapas, beyond Mexico City? What would be the Beltway, I guess, the more informed, attentive public? Do you think that the court hasn't yet, or the importance of the court hasn't yet reached the electorate or the most remote understanding, civic education understanding of the Mexican people to to see that it should be an important calculation in their own exercise of their political rights. How do you view the court? Because I feel that sometimes people don't quite get the importance of this institution, this branch of government.
I think that's true anywhere you look in the world. People go along their lives, and nobody really takes the time and stops and reflects on what the Supreme Court is, what its role is. It's not an elected branch of government, so the justices aren't out there trying to get votes or trying to get funding. So you never hear. People's lives are very busy, and it's very hard for them to stop and reflect and say, "Look, there's a Supreme Court, and these are the rights I have." People tend to take for granted the rights they have. So it's a very tough sell, the Supreme Court, and I think we're going to be in the ballot box this next electoral cycle, and it's a very tough sell.
Related to that, in the United States, given the perceived corruption of some of the Supreme Court justices, Clarence Thomas comes to mind, who's accepted gifts and certain privileges from wealthy individuals whose cases have actually been before the court. The U.S. Supreme Court has lost a little bit of legitimacy and ground on that. They recently introduced a code of ethics. Can you tell us a little bit about your own code of ethics in the court? And because I think that helps protect the court and give it the legitimacy and also improve its perception among the public. Is that something that you have, that it's needed, that should be required? Is there a code of ethics, much like the one that seems to be taking place in the United States, barely now, by the way?
Yes, we published our code of ethics in 2003. We're about to publish a newer version of our code of ethics, but we've had a code of ethics around for some time now. The problem with being a judge is there's always going to be one party that's not satisfied with your decision. No. And usually when their decisions aren't, or when their arguments aren't strong, well then ad hominem disqualifications become the recipe of the day. So we are constantly subject to accusations, we are constantly criticized, and we are constantly praised by the ones that won. So judicial independence is fundamental, and certain judicial protections for judges, and that's long tenures, not lifetime tenures, but 15-year tenures, so they can separate from the president that named them, for example, and they can start creating a body of jurisprudence through their day-to-day decisions. Financial independence, the budget has to be protected so that the other branches of government can't punish the judiciary with budget constraints. And there are several different types of. That said, justices have to take precautions in their daily lives, in their conduct, because they will be subject to criticism for many, many, many reasons. So a code of ethics is fundamental to the well-functioning of a court.
That's one of the reasons why we really appreciate your presence here at the Baker Institute, because we know the gravitas of your position in the court and in the Mexican political system, and so we certainly appreciate your candid responses. I want to open it to questions from the audience. Yes, sir. Oh, yeah. At the bottom of the microphone, there is a little button, a gray button. You need to turn on the.
Yeah, okay.
So
I'd just like to get some ground rules about how many judges there are, because I've heard different things. How many judges? What are the terms of the judges? How many in your own case? How long is your term? And you made a comment about a ruling that it required 8 votes to pass a certain make a certain opinion. So We haven't got exactly the ground understanding
basics,
of
yeah.
the basics of the system.
Law 101, so to speak, or Supreme Court 101. Yes.
I'll glad to explain. Um, we're 11 justices on the Supreme Court. We can decide cases en banc, all 11, or we can split out into five judge panels. The president of the Supreme Court will never sit on the 5 judge panels. That would be left to the other 10. Minor issues are on 5 judge panels, and we sit en banc. The way a justice gets to be named a justice is different from the U.S. The president will send 3 names to the Senate. The Senate must vote 2/3 to confirm of those 3 names. If the Senate rejects the 3 names, the president can send 3 more names. If the Senate rejects the second round of 3 names, then the president can appoint directly. So we would never have the situation where, for example, Merrick Garland, where there's an incentive for the Senate to decide of those 3 names. 15 years. And the Senate votes by 2/3 majority, and it's by ballot. It's the only time the Senate will not publicly, the senators will not vote in a public fashion. That's to avoid having party votes. So it's very hard to get on the Supreme Court. And there are different writs. The writ of amparo, which is the most common way to get to the court, that those cases are decided by a 6-vote majority. It will be an obligatory president if 4 justices, if we're sitting in a 5-judge panel, vote on the case in the same way. It will be obligatory for all lower federal courts. If we're sitting en banc, we need 8 votes for it to be an obligatory president. And by obligatory, I don't mean stare decisis. I mean a judge will be sanctioned if they don't follow the way the court ruled. And then there are 2 other constitutional remedies, controversia constitucional and the writ of unconstitutionality. With the writ of unconstitutionality, we will decide the constitutionality of a law without case or controversy, in abstract. Standing is granted to a legislative minority, 33%, human rights commissions, or states. And there we need 8 votes out of the 11 to declare the law unconstitutional. If we declare the law unconstitutional in a writ of unconstitutionality, the law ceases to exist. It's repealed by the Supreme Court. So it's a very powerful instrument, but it requires a supermajority of 8. And controversias constitucionales, basically, that is where those are constitutional remedies reserved to federal state issues or division of power issues, where we basically act as the arbiter between the different governmental bodies. How a case can get to the court, there are 5 ways. One is the amparo, which is a lawsuit, as you would have it here. The other one is a controversia constitucional. The other one is the acción de inconstitucional. When circuit courts have different opinions, different criteria, the case will be up to the court, and we will decide the differences between the 2 circuit or more circuit courts that are having a debate, or we can grant cert, much like the U.S. grants certiorari. Those are the 5 ways a case can get to the court. I don't know if there's anything else.
Yes.
A follow-up question: how can a judge be removed other than by death before their 15-year term expires? How many have been removed?
There's only been 3 justices in the 200-year history of the institution that have left alive, other than retirement from the Supreme Court. The first one was in 1931, Vázquez de Mercado. The second one was in 2019, Eduardo Medina Mora. And the third was in last month, Arturo Saldívar. In order to resign from the bench, you have to send your resignation to the president of Mexico, and the president of Mexico sends the resignation to the Senate, and the Senate has to vote by simple majority on whether there is a just cause to leave the bench. And that's only happened 3 times in 200 years.
Without
Voluntary resignations have only happened 3 times in 200 years. That would be death.
Once in the Supreme Court, they cannot be removed for cause.
Yeah, you can be impeached. But that would be a regular impeachment process, very similar to the U.S. impeachment process.
I want to touch on that because
that's never happened.
I want to touch on that because I think hidden in your question is again the question of the political environment, right? Because the Supreme Court is swimming in the political environment of the country, and we know that the resignation of Eduardo Medina Mora, although a resignation, there are forces pushing behind him, and also Saldivar, just recently resigned, although I think he's in the 14th year, I think. Is
14th year.
He's only got 1 year left, or had 1 year left. Was also probably politically motivated. And that is one of the biggest concerns today in Mexico, that the Supreme Court may be somewhat under siege, because if there's 3, and one in 1931, you said?
1931.
And 2 under this administration, then it means that there is a clear siege of the executive over this Supreme Court. I mean, obviously you can say what you need to say, but it would seem to me that clearly that signals that the court is facing headwinds, political headwinds, in Mexico today.
Well, let me first a little historical context. I often remember, and I'm a history buff, so I often remember the Roosevelt era, and here you have the morning talks. Back then, you had the fireside chats.
Mhm.
And if you read what President Roosevelt said or would say during his fireside chats about the court at that time in the 1930s, it's much worse than what the president has said about. Well, maybe the same as what the president has said about us.
Well, he threatened court packing, which López Obrador did at some point, right?
Well,
he threatened
right now
to take the numbers from 11 to 15 or something like that.
Yes. The difference is we still haven't had a switch in time. The court has been very consistent with its votes, and I think it will be continue to be very consistent. The executive, he has been very vociferous in his opposition to the court, but I will challenge you to find a ruling by the Mexican Supreme Court that he has not abided by. So one thing is the political discourse,
or blister,
and the other thing is the reality of complying with the rulings by the Supreme Court. He may not like them, but to this day, he has complied with every single decision the court has made.
Yes, sir. Turn on your microphone, everyone.
I have a procedural question. When a decision is issued by a court that is not Mexican, for example, the Inter-American Court of Human Rights, is their decision applied then directly to the court where the original decision that they're worried about, or do they return it to you and say, apply what we're saying? What's the procedural rule for that?
For legal buffs, that's a very, very, very interesting question.
I'm an international lawyer. I can't help myself.
The way it's happened, and it happened for the first time in Radilla, the Inter-American Court decided the case, and the court, its decision does not bind us, it binds the state. But certain things that were said in the Radilla ruling implied the Mexican court, shortcomings of the Mexican court. And so we opened a varios, which is a file. It was assigned to one of the justices, and basically that justice was tasked with the issue of saying, what the hell do we do? And so this file was brought to the 11 judges review in order to comply with the ruling by the Inter-American Court, even though the Inter-American Court was binding the state and not binding us. There's a recent ruling on provisional detentions before reaching a ruling. We have a list of certain crimes that mandate obligatory provisional detention. And the Inter-American Court just declared that is wrong. And we just opened a file to see how we're going to handle that issue. You could say it's a moral obligation to comply with the standards of the Inter-American Court.
Yeah.
Good morning, and thank you for being here. This has been fascinating. What are the circumstances, if any, under which the court exercises original jurisdiction in a somewhat related part of the question? How often is de novo review used by the court in the cases that come before it?
Sometimes we'll stretch the appeal and it'll be a de facto de novo review, and sometimes we will exercise original jurisdiction. I would say maybe 10% of the cases that we review. We do have the authority to do it, but we will generally just decide the constitutional question and then remit it back to the circuit court for the legality. We generally won't get into that, but on certain occasions we can, and we definitely have the authority to do that.
Thank you. There and then here, yes.
I'll make my question in Spanish just because it feels odd. Muchas gracias por la ponencia, ministro Gutiérrez. Creo que, y quiero insistir en lo que dijo el doctor Payán, uno de los temas que ha habido este año en paralelo en la Corte Americana y la Corte Mexicana ha sido el tema de ética. Y me refiero, bueno, al caso que mencionaban de Justice Thomas y en el caso de México al caso de la ministra Esquivel. La pregunta que tengo es, además del código de conducta que ahora menciona que se va a publicar, ¿han pensado en otras formas para controlar este tipo de casos? Y segundo, ¿hay una posición institucional de la Corte en el caso en el que se confirmara que el título de la ministra Esquivel es nulo? ¿Tendría algún efecto para las sentencias en las que se ha pronunciado como ministra de la Corte, siendo que el requisito de ser abogado está mencionado en la Constitución? Gracias.
No, mira, let me answer in English because for the rest of the people here, let me put this in context. There was an issue where the thesis for obtaining a law degree of one of the justices was called into question, that she had plagiarized when she was in law school. So this obviously became a big scandal because you need a law degree in order to be a justice. And the question that has been asked first, well, what is the position? The position of the court is that's a decision for the Senate to decide. We don't name, we don't remove justices. That's the purview of the Senate. And if we were to change that, we would weaken our independence. Our independence precisely rests on the fact that our nomination and our removal requires a dialogue between the three branches of government. So that for us is very important. It's a Senate issue. It's not an issue of the Supreme Court. It would have no effect on previous cases. Those cases have been decided, and there is nothing that can ever change a decided case by the Supreme Court. Basically, I think we have to wait and see for the university to decide, and then for the Senate to decide. And it has to run its course. There's nothing that the Supreme Court can do or opine on that specific issue.
Yes.
Justice Ministro, bienvenidos a the great state of Texas. And Dr. Payan, thank you so much for inviting me, and congratulations on your great success here. Tengo una pregunta sobre la leyes comercial contra la patrimonio nacional. The tension between the commercial laws in Mexico and the patrimonio nacional. And I love Mexico. I'm bullish on Mexico. I see a great expansion of Mexico, all right? But it seems to me over the course of these different presidential administrations, there's an expansion and a contraction of the concept of the patrimonio nacional against the commercialization of certain areas of Mexico. Are you following me, sir? It seems, does the Supreme Court, is there some way to stabilize that expansion or contraction of the reach of diminishing commercialization of the patrimonio nacional for the benefit of both the commercialization of the patrimonio nacional and the expansion of the Mexican economy?
Thank you.
Oil and gas.
We're in Texas, sir.
It's a big issue in Mexico. And let me try to put it into context. If I were to say, why the Second Amendment? Why gun rights? Can we repeal the Second Amendment? Is the gun rights correct? Those are issues that go to the core of certain American beliefs. It's tied to the idea of freedom. It's tied to the idea of individualism. It has very profound meanings in U.S. culture. For Mexico, oil hits those same strings that define what Mexico is. You have to understand, we fought a revolution over this. And it's a very, very, very difficult issue for us to deal with, much like gun control is in the U.S. And I have to use that parallelism because it's the one that it touches very strong sentiments in Mexico. Oil. So yes, you're going to have administrations that are very bullish on the private sector exploiting oil and gas, and yes, you're going to have administrations that are going to be very nostalgic to an era when Mexican oil company dominated the country. I don't see that issue being resolved, quite frankly, easily or in a short term. It's a very, very, very sensitive issue for Mexicans, and you have people on both sides of the spectrum. I think the economy is going to end up solving the issue by itself because Mexico cannot grow if it doesn't have a modern energy policy. But I think we're going to have to muddle through these issues. I know it's hard for Americans to understand this because it's an economic good and let's just exploit it and let's But for Mexicans, oil has a very, very specific place in its history, and it's not. I don't think it's a rational decision. I don't think it's an economic decision. I think it's something that we have to work through historically in order to get it
And
resolved.
also, if if I may expand just a bit on that question, evidently in the United States, the judiciary cannot attract any controversies that or cases that don't come before it. It's a reactive court, so this has to play out in the political system. It has to play out in the public conversation, and the court can only respond to what comes to it. Right? It's not like
And
the court can.
there are a lot of cases right now pending on the court with the 2014 constitutional reform, which opened up the energy sector. They will be adjudicated relatively soon. I don't think that they're going to take much time. They're at the circuit court level. I'm sure the court's going to grant cert, and I am sure we will decide these cases relatively soon, if not the next term, the term after that. I don't see it moving much faster than that. The 2014 reform was a watershed in Mexico. It changed a lot, and they're constitutional provisions now. And so we'll see how those go in court, but they will be adjudicated relatively quickly.
Rodrigo, you keep time and tell me, but here we have a question. Yes, sir. Two more questions. Okay. Yes, sir.
Hello. Thank you, Minister, for coming today. So I just have like a couple of things to say. The first would be that probably the last time, and please let me know if I'm wrong, that justices were actually removed. It was with the judicial reform of 1994, where all the justices were removed one day from another once it was approved. And that was pushed by President Cedillo, if I remember well. I was born that year, so it's not like I remember.
So you remember well.
Yeah. Like if it was yesterday. Now, the second thing is that I don't know how to translate the name of the Consejo de la Judicatura. Do you feel, and probably you can expand more on the topic, like how does it work, and what if there is a parallel of that structure here in the U.S. But do you think that the Chief Justice of Supreme Court in Mexico should also be the president of the Consejo de la Judicatura? And I think that'll be all. Thank you.
Yeah, I didn't mention the 1994 because it was by constitutional amendment. Basically, it was a 26-judge court, and it was a court of legality, and the court was the Constitution was amended to reduce the number to 11, but it came with these constitutional remedies that I mentioned. So it was part of the structure to change the court. But yes, all but 3 justices were retired by constitutional mandate. But that's different from voluntarily wanting to leave. And the other question, the Consejo de la Judicatura, I really don't think it's important, to be honest with you, whether they're on the court or they're not, or they're president of the court. I think it's been used to dodge the real issues and the real reforms that have to take place. I think the Consejo de la Judicatura, just to put it simply, all the back office of the federal judiciary is entrusted in a group of 5 judges that leave or have license from their jurisdictional work, and they form part of the Consejo de la Judicatura, and they make all the back office decisions. What paper to buy, what offices to rent, where to put new courts, whether you need a new circuit court, whether you need to downsize in some place judges, or whether you need more district judges in some place. That's the type of thing. They also decide where a judge is going to go, whether it's in these federal judges. This federal judge goes to the state of Oaxaca, or they apply exams. Becoming a judge or a circuit court judge requires passing very strict exams, and then once they pass the exams, The Senate does not participate like they do here in the U.S. Once they pass the exams, the Consejo decides where they go, whether they go to Chiapas or whether they go to Oaxaca, and they also sanction. They're the sanctioning body of judges and circuit court judges, where there's corruption or whether there's whatever sanctionable conduct has occurred. That's the Consejo de la Judicatura, and the way it's the court names 3 judges to the Consejo de la Judicatura. The Chief Justice sits in el Consejo de la Judicatura, and 2 more are sent by the Senate, and 1 more sent by the executive branch. So there's 7 that form the Consejo de la Judicatura, and they decide all the administrative issues and the sanctioning issues of the federal judiciary. That's the Consejo de la Judicatura. And there's a big debate whether the Chief Justice should sit there or not.
I'm going to take the freedom to for a couple more minutes to take 2 or 3 of the questions here, and then there's a pen if you want to gather the questions all at once, and then we'll close after that. Yes.
I first want to say thank you so much for coming to address the Baker Institute, and thank you for your insights in the Supreme Court of Justice. My question is, with President Obrador ability to appoint another judge today in the Supreme Court of Justice, do you see a possibility of a re-election? And what cascade of events would have to happen for this to take place?
Okay. And I saw another hand here, another one there, here, and then Perez Mo. Yeah.
Thank you. It's clear that in Mexico there's a big gap in knowledge of the people about the Supreme Court's role in the democracy itself. And what would be your thought on how we as regular citizens and business owners, what can we do to help the country address this knowledge gap? And if there are any instances or any efforts already in place to get this to the knowledge of the people where we can join and support.
And last question. Yeah.
Well, thank you very much for your enlightening presentation, Justice. I just have a question related with the specialized courts that started in 2013 with the reform of the Constitution. I mean, what would be your opinion on trying to open a little bit more that specialization? I mean, today is on competition and telecoms, but to have more economic and law cases for specialized judges like intellectual property rights, like international trade, anti-dumping, some issues related with the network sectors like transport, energy, so regulatory issues on that. What would be your opinion on that?
Okay, we'll close with those questions. Not small, but last.
Okay, re-election, impossible. And I mean impossible. There are certain structural definitions that a country makes when it decides on its constitution. One of them, and they're there even though they make the country more inefficient. The inefficiency is a price worth paying against having the power accumulate in a single person. One of the protections is division of powers, vertical division of powers. And the other one is horizontal division of powers, federalism. They make government very inefficient, but we agree to pay the price of having a more inefficient government versus the risk of having power concentrated in a single person. In Mexico, there's a third, and that is a constitutional commitment to no re-election. And it's very hard to appreciate just how important no re-election is in Mexico. Our federal system now looks more like a centralized system, and every time We have a national issue. Our knee-jerk reaction is to centralize it. Our division of powers right now is dominated by one political party. So the only protection we have against concentration of power is no reelection. And I really feel Mexicans feel very, 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 very strongly about that issue. So I'm usually very guarded, and I would never say never. On this issue, I would say never. It's a very, very strong belief in Mexicans about no reelection, especially on the presidential level. So I really would see very little risk in that. Vote. That's probably the most important thing any citizen can do is mobilize and vote. More than convince people about the Supreme Court, I think the most important thing anybody can do is convince people about the importance of going out and voting. That's the bedrock of any democracy. Specialized courts, I personally, I don't like them. I think specialized courts have an enormous risk of being co-opted by the economic agents that have to go before the court. So I'm very, very, very weary of specialized courts. I understand the virtue of having judges that are very technical in the understanding of the issues. But I think it's extremely easy to have them overtaken by the economic agents. So I tend to be very, very, very weary about specialized courts.
I want to remind you that on December 7th, we have the Mexico Country Outlook for 2024. It's an all-day event. It's going to be here downstairs on the atrium at the Torrey Commons. It's an important event because that's when we try to forecast what we think is going to happen in Mexico in 2024. That's our capstone event at the end of the year. That's December 7th. You can go online and register under the Mexico Center and then under events. So, and please help me thank our stellar guest today, Justice Gutiérrez.